Thank you, Mr. Hibner. Good afternoon, ladies and gentlemen, and welcome to the continuing docket of the Tennessee Supreme Court on this September 30th, 2020. As we have done on two previous cases this morning, we are continuing to handle our docket or oral argument dockets by video conferencing. We also welcome those of you that are watching our live stream on the YouTube channels for these cases. We have chosen to proceed in this manner so that we can continue moving our dockets along while at the same time protecting the health and welfare of everyone related to the justice system. And I do appreciate the lawyers for participating this way. We certainly recognize that this is not something that we all have been used to for a long period of time, but it has become a rather efficient way for us to continue moving our dockets forward and for the cases not to linger any longer than they have to at any particular level. And it has, I think we're going to learn that we've been able to utilize this, but we'll be able to utilize this in a lot more ways once we are finally able to get back to some sense of normalcy with what we've learned from that, by the fact that all of us have gotten outside of our comfort zone. So we can make good with what's happened on that. In just a moment, we'll begin the third case of our oral argument docket here today. Each side will have 30 minutes for arguments when we begin. Would ask the appellant, if you wish to reserve any time for rebuttal, please do so at the beginning of your argument. And there will be a clock in Mr. Hibner's screen that will indicate how much time is left for each side for the oral arguments when we begin. With that, Mr. Hibner, will you call our next case, please?
State of Tennessee versus Shalonda Weems.
All right, Mr. Ward, you ready to proceed?
Yes, Your Honor. Good afternoon, Your Honors. May it please the court. My name is Garrett Ward, and I'm here this afternoon on behalf of the state of Tennessee in the matter of Shalonda Weems. If I may, Your Honors, I would like to request 5 minutes for rebuttal.
All
right. Your Honors, on September 3rd, 2004, Carmen Weems was born. 5 months and 26 days later, she passed away. At a trial examining the events surrounding her death, the state put on evidence establishing that Carmen Weems died of chronic malnutrition and dehydration, that her caretaker in the months and days leading up to her death was her mother, the defendant in this case, Shalonda Weems, that Miss Weems, in the time between Carmen's birth and death, received repeated instruction on how to and how much to feed her child, and that in the days leading up to Carmen Weems' death, she was not fed. From this evidence, the jury convicted the defendant of aggravated child neglect. And so concluding, the jury found that the child was treated in a way, she was not fed, that caused her serious bodily injury, in this case, death. And crucially to this case, the jury found that this treatment was committed by her mother and was done with a knowing mens rea. Following the jury's verdict, defendant filed a motion for judgment of acquittal with the trial court. At this juncture, the sole legal inquiry to be considered by the trial court was whether or not the state had introduced sufficient evidence to support the jury's verdict of guilt for aggravated child neglect.
Mr. Ward, this is Justice Bivens, if I may interrupt you there. I think I have a few questions from a procedural standpoint, exactly where we are in this case. And I think you started
yes, Your Honor.
To that. My first kind of a preliminary question, is there anything in the record that indicates why there were over 10 years before this defendant was charged in this case?
No specific reason is provided in the record, Your Honor. From my examination of the record and some discussion about this, it seems that that this prosecution simply fell through the cracks.
All right, my second question then is more directly right down. Am I correct that there was simply a motion for judgment notwithstanding the verdict filed? It was not coupled with a motion for new trial or a request of the trial court to exercise its discretion as a 13th, it's to exercise its duty as a 13th juror?
That's my understanding of the record as well, Your Honor. And certainly the trial court's ruling was very specifically cabined to a ruling on a motion for judgment of acquittal.
And there's been no sentencing hearing of any type in this case yet, correct?
Not to my knowledge, Your Honor. Following the motion for judgment of acquittal, the state that was granted by the trial court, the state appealed.
So what's your position with regard to, let's assume for a second we were to rule in the state's favor in this case, what's the next step for this court as far as remanding the case, or what needs to happen at the trial court level?
Your Honor, I believe this case would be sent back to the trial court for consideration of further matters of potential motion for new trial, sentencing hearing, things of that nature.
All right.
Well, this is Justice Page. There'd be a sentencing hearing first, then a motion for new trial would be on the table, correct?
Yes, Your Honor.
This is Justice Clark. Has there been a motion for new trial as to any part of this case? Because there was a second conviction which is not being challenged. Is it just still sitting in the trial court waiting for the resolution of this part of the case?
That's my understanding, Your Honor. At the point at which defendant filed her motion for judgment of acquittal, the sole legal inquiry was sufficiency of the evidence. It carries with it all of the typical accoutrement of sufficiency review. The trial court was bound to view the evidence in the light most favorable to the state, bound to disregard countervailing evidence, and bound to make all reasonable inferences in favor of the state.
Mr. Ward, this is Justice Page. You've just recited the Jackson versus Virginia standard, so it's clear that applies here, correct?
Yes, Your Honor, this court commented on the standard for grants and reviews of grants of motion for judgment of acquittal in Finch, which was a 2007 Tennessee Supreme Court case. So it's clear that the correct legal standard here, the only appropriate legal standard that to be considered by the trial court, and as the Court of Criminal Appeals review was done de novo by the Court of Criminal Appeals and intermediate appellate review, was the sufficiency standard as set out in Jackson versus Virginia.
Is there any evidence in this record of direct evidence of knowing conduct by this defendant? I'm asking, is everything based on circumstantial evidence of knowing conduct?
Your Honor, it is the case here that the evidence supporting the defendant's mens rea is circumstantial. I would note that's not out of the ordinary. It's the odd case where there is an affirmative statement of intent or knowingness by a defendant, and it's often the case that the state is left to prove its the requisite mens rea for a charge based on circumstantial evidence.
And what evidence, circumstantial evidence, is in this record to support knowing mens rea?
Certainly, Your Honor. I would point to several different pieces of evidence introduced by the state at trial supporting a knowing mens rea. First, Your Honor, it's clear from the medical proof that the victim's cause of death was starvation and dehydration. The medical examiner testified that based on the child's gastrointestinal tract, that she had not been fed in the days leading to her death. On the other hand, the defendant here opined to investigators when this crime was being investigated that she had, in the days leading to the child's death, fed her a diet of milk and cereal and applesauce. Given the conflict between the medical proof and the medical examiner's testimony and the defendant's testimony here, when viewing this conflict in the light most favorable to the state, I believe the jury would have been well entitled to conclude that the defendant was lying to investigators, was attempting to cover up her actions by giving a false feeding regimen that she did not actually take with the child. And Tennessee courts have noted previously that untruthfulness in criminal investigations is circumstantial evidence of knowing action. On top of that, Your Honor, the medical examiner, after concluding that the victim's cause of death was dehydration and chronic malnutrition, testified as to a number of external conditions on Carmen Weems's body that demonstrated her rapidly deteriorating condition and would have been noticeable to a layperson like her mother. The medical examiner noted that Carmen Weems's eyes and her fontanelles were sunken into her skull, that she was experiencing hair loss, that she had doughy patches of skin all over her body, that she had incredibly cracked and dried lips. Medical examiner, in no uncertain terms, testified that all of this was evidence of malnutrition and dehydration, and that these were conditions that could be noticed by a layperson. And Justice Page, the state had more circumstantial evidence of mens rea in this case. The state put on evidence in the form of Carmen Weems's medical records and testimony from a daycare provider who provided some care for the child during her short life, that this defendant, Shalonda Weems, repeatedly received instruction on how to feed her child and on how much to feed her child. Shortly after Carmen Weems was born, the defendant demonstrated the ability to properly bottle and breastfeed the child. The defendant received instruction from neonatal medical personnel on how to properly mix formula and on how much formula should be given to this child. At approximately a 2-month wellness check, the child was slightly behind in terms of expected growth, and there was some questioning of the defendant on feeding, and this notion came out that potentially she had been watering down some formula for this child, as she admitted she had done with her previous children, and she was told in no uncertain terms that this was inappropriate. And then when she took her child to daycare, she sent along as nourishment, juice, and water. This was noted by a daycare professional at the facility she took her child to. And this professional, in her own words, said that she told the defendant, "You are feeding your child wrong. That a child of this age can't merely be receiving juice and water as nourishment. That they need to be getting milk or formula or food of some sort, something with more caloric value than milk and juice." And lastly, Your Honors, I would note that the child experienced a rather dramatic loss in weight between a wellness check, which occurred at the end of January, and her death, which occurred at the beginning of March. During this January wellness check, Carmen Weems weighed a little over 11 pounds and 6 ounces. By the time she died, she had lost almost 10% of her body weight. She was slightly above 10 pounds and 5 ounces. This severe weight loss is another condition that would have been noticeable to her mother. This would have been noticeable to a layperson. So from this circumstantial evidence, Your Honors, viewing all of it, the child is suffering from malnutrition and dehydration. These conditions are expressing themselves in a number of external conditions on her body that would have been noticeable to a layperson like her mother, particularly a layperson like her mother who received specific and repeated instruction on how to properly care for her child, how to properly feed her child, both in terms of feeding technique, and in proper feeding amounts and materials. So from the circumstantial evidence and the fact that the medical examiner testified that the child would not have been fed in the days leading to her death, that the idea that the child was fed in the days leading to her death was inconsistent with her empty gastrointestinal tract, combined with the defendant's attempt to mislead investigators by offering this feeding regimen, which was contradicted by the medical proof. I think that is a very compelling and very strong circumstantial case to support a knowing mens rea here. It's worth noting that aggravated child neglect is a nature rather than a result of conduct offense. All the state had to show in this case to support its verdict with regard to the knowing mens rea is that the defendant knew she was not feeding her child. I would contend, Your Honors, that based on the evidence the state introduced, that it was easy for the jury to reach this conclusion. This begs the question, how then did the trial court and the Court of Criminal Appeals come to the opposite conclusion? And I believe, Your Honors, some light is shed on that in the opinion of the Court of Criminal Appeals. The Court of Criminal Appeals, in its opinion, faithfully recites the same standard that I provided to this court at the beginning of my argument, that they were merely conducting sufficiency review, and noted that they should view the evidence in light most favorable to the state, disregard countervailing evidence, and draw inferences in the state's favor. The Court of Criminal Appeals then proceeded to do none of that. Instead, the Court of Criminal Appeals chose to, on numerous occasions, accredit evidence offered by the defendant above the evidence offered by the state in a way that the jury clearly did not, and in a way that is inconsistent with sufficiency review, which is what the court acknowledged it was supposed to be applying in this case. For example, Your Honors, the court notes that the defendant steadfastly insisted, in the face of questioning by law enforcement, that she fed her child, that in the day leading to her child's death, she fed her child milk and cereal and applesauce. And the court points this in an accreditory manner, and its opinion suggests that the Court of Criminal Appeals buys the defendant's story here as far as feeding. The problem is that was contradicted by the medical proof. The state's medical examiner testified that the child's gastrointestinal tract was inconsistent with the defendant's feeding regimen. Well, in a scenario where the Court of Criminal Appeals was bound to view the evidence in the light most favorable to the state and disregard countervailing evidence, the Court of Criminal Appeals, I would contend, was bound to, as the jury did, accredit the state's proof here. The jury, as evidenced by its verdict, believed the state's medical examiner that this child was not fed above the defendant. But the Court of Criminal Appeals, by its opinion, seemingly did the opposite, seemingly supplanted the jury's determinations with regard to weight and credibility on these two witnesses with its own. The Court of Appeals does this again when it points to the defendant's alternative explanations for how her child starved to death. The defendant suggested at trial that perhaps there was a defect in the aperture of my baby bottle that I used to feed my child, that it was just a little too small, or my method of feeding my child involved propping this baby bottle up, and that was ineffective. The Court of Criminal Appeals points to these innocuous explanations for the victim's starvation, again in an accreditory manner. But it's clear from the jury's verdict that the jury believed the defendant did not feed her child, that the jury rejected these innocuous explanations. But despite the jury's rejection of these explanations, the Court of Criminal Appeals points them and holds them up as evidence that the state did not prove a knowing mens rea. Your Honors, perhaps the problem with this case can be most succinctly summarized by the defendant. The defendant in her brief says that it's clear that the trial court did not accredit and did not believe the state's witnesses, did not place weight on the state's testimony. And frankly, I agree. I think the trial court did not place weight on the state's testimony. I think that the Court of Criminal Appeals, as evidenced by its opinion, did not place weight on the state's evidence or accredit its witness testimony either. And therein lies the problem. This case came before the trial court and before the Court of Criminal Appeals on simple sufficiency review. There was no room in either court in conducting the review to choose to reweigh the evidence, to choose to accredit certain pieces of evidence above the evidence offered by the state. The Court of Criminal Appeals acknowledged that there was no room for this in their own opinion, and then turned around and supplanted the jury's weight and credibility determinations with their own. This was a misapplication of the standard of review for reviewing a grant of a motion for judgment of acquittal, and it was erroneous, and it is a basis for reversal. And if this court has no further questions, I would ask that this court reverse the judgment of the Court of Criminal Appeals.
So, counsel, if we end up agreeing with you and the case goes back for a new trial, the trial court has already pretty much signaled what it will rule on a motion for new trial on this charge. I mean, you're talking about a new trial on this charge 15 years or so after the child died.
Honor, if were this case to be remanded, the trial court would, in my estimation, still have the ability to rule and sit as the 13th juror.
Didn't he? I mean, he pretty much telegraphed how he would rule on that, right?
And if this case should re-arise in his court, he may do so. However, what he did here was misapply the standard of review for granting a motion for judgment of acquittal, granted motion for judgment of acquittal, and ended prosecution. Had the trial court wished to sit as 13th juror and make a 13th juror determination when this motion was before it, it could have done that. However, it's clear from the record that it did not. It's clear from the record that the trial court sought and thought he had fully ended this prosecution by granting the motion for judgment of acquittal. It specifically notes by its actions that the state has no right of appeal. So yes, Your Honor, this case might, should it arise before the trial court, he might order a new trial, and that would be the way things are. But the course we took to get here was improper and relied on an erroneous application of Tennessee law.
Thank you, Mr. Ward. Mr. Colabecchio?
Yes, Your Honor. Thank you, first of all, Mr. Ward and Your Honors, for granting us this time. What I would like to do, much as Mr. Ward did at the beginning, was to reiterate the facts of the case and the procedural aspects of the case without covering the same exact territory. What occurred here was that Miss Weems had her child in September, and over the next few months took the child, Carmen Weems, to all of the regularly scheduled doctor's visits. And it's interesting to note that while the state's characterization of the instructions that Miss Weems was given about feeding the child as repeated, somehow in the record it shows that she was given the normal instructions that any other mother would have been given. And there was no notation that they had to repeatedly, in the record, give her instructions. She was given the regular instructions, told and showed how to feed the child, breastfeed and bottle feed. And it appeared that that was working just fine. Now, it's interesting to note also that in the reports, from the medical reports, from the doctors that are in the record, indicate that the child was, and I think the exact terminology that was used was that the child was well developed, well nourished, alert, and vigorous. And these were reports that continued until just approximately 4.5 weeks prior to the child's death. The last scheduled doctor visit that Miss Weems took her child to was, I believe, the 29th or 30th of January. Excuse me. And approximately 5 or so weeks later, 4.5 to 5 weeks later, Carmen Weems passed away. The few days before Carmen Weems passed away, Miss Weems had returned to work and was by that time taking her child to the daycare center, where Miss Owens, who testified, indicated that she never had to turn Miss Weems away from the daycare because the child was not being fed properly.
Well, counsel, this is Justice Lee. With all due respect, in reviewing this issue, we're required to discard any countervailing evidence. And you're citing evidence as you would as if you were arguing to a jury why your client should be acquitted. But we've got to disregard or discard countervailing evidence. So there are some good things that you can bring up about your client, but that's not what we're allowed to consider at this stage of the case. So what are we to make of that?
Well, I was merely trying to flesh out the rest of the record about what occurred, not necessarily using it as argument, but putting it out there to fill out the rest of the record. And just to briefly continue on that one particular thing, a few days before, Miss Weems took the child to the daycare. Both Miss Weems and Carmen Weems, the child, were obviously sick. They had been throwing up. So the daycare said, you really can't let this sick child come to daycare. So she was turned away. She received some help, Miss Weems did, over that weekend from her mother in taking care of the child while they were both sick. And then a few days later, unfortunately, the child passed away. Now, Rule 29 of the Rules of Criminal Procedure is not very flexible. We would assert that when applying Rule 29 to any case in a trial court, for a judgment of acquittal, it addressed the simple controlling tenet of Rule 29, which is sufficiency of the evidence, as opposed to Rule 33, which concentrates on the weight of the evidence, which is statutory correct. Now, the state has argued that the state only had to prove that Ms. Weems was aware she was not feeding the child, and that this was knowing, and that's the standard that applied. This comes down to whether or not she knew whether she was feeding the child or not.
Mr. Colavecchio, this is Justice Page. You agree this is a nature of the conduct offense and not a result of the conduct offense, correct?
That's correct.
So look at what she did, not the result of what she did, correct?
Correct.
And you also agree that basically under 29E, our cases cite basically the same standard that we have under sufficiency Jackson versus Virginia. Justice Lee recited part of it earlier, right?
Yeah, correct.
So tell me why, when we apply that, we should rule in your favor in this case today.
Well, her conduct, which is what is in question here, it is shown that her conduct was that she fed the child according to herself, according to the proof from her mother.
Well, Mr. Colavecchio, let me interrupt you there and follow up on both Justice Lee and Justice Page's question. Once again, you're reciting evidence that the defendant herself offered. And it's clear from the trial court's decision and from the Court of Criminal Appeals decision that both of those courts considered that evidence as well. How, under the proper standard, can we consider that at all in our determinations of the motion, whether to affirm a judgment of acquittal?
Well, Your Honor, I'm not sure exactly how to answer that, other than to explain that our assertion is neither of those courts addressed these issues under sufficiency, or I'm sorry, under weight of the evidence, just about sufficiency.
But they consider that, but the standard requires that they put aside any evidence offered by the defendant in the defendant's favor, whether it be the defendant's testimony or anyone testifying on behalf of the defendant. That's exactly what you're relying on in that portion of your argument. I
understand that. Excuse me. Well, I would assert that the state's own evidence indicated that, and this is not evidence put on by the defense, but evidence that was put on by the state, was that no one that testified for the state had any concerns just a few days prior to Carmen Weems passing away of any issues with the child being fed by the mother. Additionally, and this is circumstantial evidence, or could have been direct evidence, was that when the police showed up at Miss Weems' house the morning that Carmen Weems passed away, because what happened was she called, the 911 was called, they came, everybody went to the hospital. Unfortunately, the child passed very quickly. Police went right back with DHS to the home to take photographs, to gather potential evidence. And among the things that was gathered, or should have been gathered, that wasn't gathered, was a blanket that was in the child's bed, in the crib. That's where some of the evidence could have turned on this case. Had that blanket been tested for saliva, for instance, and this was something that was brought out in examining the medical examiner and the doctor that was involved in the trial, that had that blanket shown evidence of saliva or food, that would have shown that. But for some reason, the investigators never gathered any of that evidence. It sat right there in a photograph.
Well, but counsel, how is that something we can consider at this stage of the case, since your client's been found guilty? That's a great jury argument. But how's that relevant for what we have to consider here? And I say that I'm really somewhat sympathetic with your client, because they waited so long to charge her. To me, it's terribly unfair to be defending charges 10 years after an event, but that's not before us either. So, I mean, if we follow the standard of review, which we're required to do, we have to disregard all that countervailing evidence. That's just such a hard hurdle for you to overcome. How do you do that in this case? Help me out on that.
Well, that's been the hard part about doing this particular appeal, is that we're kind of hogtied in a sense. To argue some of the things, or to remind the court of some of the things in the record. And quite frankly, that's one of the things that I can do, is remind the court of what is in the record that wasn't raised or that wasn't controlled by the defense.
Mm-hmm.
And that's some of the things that I wanted to remind the court about. And so I acknowledge that one of the problems with all of this is that the period of time of 11 or 12 years before they even indicted the case was an issue, naturally. But as far as what evidence was put forth, not by the defense, the proof simply is that there was no knowing aspect applied incorrectly to Miss Weems's conduct. I don't know.
Counsel, this is Justice Kirby.
Yes.
How do you look at the medical evidence apart from the passage of time? I brought that up earlier, and I'm sympathetic to it, but you've got solid medical evidence on the cause of death and the child's condition that is fundamentally at odds with a sudden problem that arose because the child had a bug and was throwing up. That is solid evidence. And the jury was free to credit that evidence, and obviously they must have. So, I recognize what your client recounted and so forth, but the pivot point is that medical evidence, which is incontrovertible, and the jury must have credited it. I don't know how, I want you to speak directly to that. How do you get around that under this standard?
In all honesty, we can't get around the medical part of the evidence. What we can point at is whether or not the knowing issue exists. And there was no proof that any conduct on the part of Ms. Weems was knowing.
Mr. Colavecchio, respectfully, I mean, what Justice Kirby was talking about, I mean, Dr. Hall's testimony and report talked about cause of death, dehydration, and malnutrition, and that there was nothing in the intestines, kidneys, or any other part of the digestive tract. Isn't that circumstantial evidence of knowing conduct on the part of your client?
It is, yes, circumstantial evidence, yes. And when the question was asked of the doctor, what if, hypothetically, naturally, because none of us were there and don't know, but what if Ms. Weems had been attempting to feed the child, but the child spit the food back up, with both of them being sick, and Ms. Weems not being in total, well, not total, but having the issue of not feeling well and the child not feeling well, she may not have noticed this. And again, that's a statement made by the defense, but that was her defense to that is, that's why there may not have been anything in the child's digestive tract is, I thought I was feeding the child, but the food wasn't staying in her system. She kept spitting it up. And Carmen Weems was sick. And that was well noted by the daycare worker that the state put on. In fact, that's the reason the child had to stay home. That's about all we can say back to that, to be honest with you.
But Mr. Colavecchio, again, back to the facts that were introduced, this is Justice Clark. The medical examiner's testimony went farther than that and talked about more than just whether the child could have spit up all her food for the last 24 hours. There was not much fat around her bowels, her abdomen, her adrenal glands. That's an indication of prolonged malnutrition. The gastrointestinal tract was empty. Vitreous fluid from the eyes indicated that sodium and chlorine levels were high. So you have a case where a mother says, I did this. The medical record says it couldn't have happened this way. The mother also says the child was rolling around and back and forth in the crib, as she usually does. And the doctor says a child could not have been doing that at this time when they were this close to death. The jury has to make a credibility determination. And inherently in their verdict of guilty, they made a determination in favor of the medical testimony and against what the mother said, which is essentially meaning they found that the mother lied about the things she said. With the standard of review that's required here, how do you overcome that?
As I said a moment ago, we're having a hard time overcoming that because her assertions and the assertions of Miss Weems's mother, Carmen Weems's grandmother, are the contradictory statements, and in conjunction with the daycare workers from a few days earlier. That's, to be honest with you, the bulk of the defense in that particular area.
It seems with respect that this is not dissimilar to the kind of case that we see more often. We don't see starvation necessarily as often, but we see child abuse cases often, and where the parent says, no, the child fell down the stairs, and we have medical proof indicating injuries that would have occurred over a period of time, No, it couldn't have occurred that way. And the trier of fact is faced with, do I credit the parent who says, no, the child really did fall down the stairs. I never would have abused this child. And the medical proof that is recounting injuries that would have taken place over a period of time that were inconsistent with the parent's version of events. We see that a lot, and juries see that a lot. And it's very clear how you have to look at the sufficiency of the evidence in those cases.
Well, I think this is just about the last thing I have to say. There is something that interestingly is consistent with the defense theory, and that is that even the jury was conflicted in its understanding, or at least in its application of the legal definitions, because Miss Weems was not convicted of second degree and knowing, which is the standard, which is the key word in second degree murder, but reckless homicide, which to me seems, or we would assert, the jury realized that this was not knowing. In that realm, they did accept and repeat it by their own actions of convicting her of reckless homicide and not a knowing homicide. And I thank you all for listening. I appreciate the comments, and I understand the difficulty with this case.
Thank you, Mr. Kovackiel. Mr. Ward for rebuttal.
Thank you, Your Honor. A couple brief points on rebuttal, Your Honors. At the end of argument, opposing counsel suggested that there might be some evidence that the jury found that his client's conduct was not knowing based on her homicide conviction not carrying a knowing mens rea. With respect, that does not speak to whether or not the jury found her conduct to be knowing with respect to the charge of aggravated child neglect. Tennessee law allows for juries to reach verdicts just like this, and their determination with respect to her homicide conviction simply does not speak to their clear conclusion that her behavior here was knowing. Secondly, Your Honors, Justice Lee, Justice Bivens, Justice Clark, you pointed out that at various points, defendant's argument bears some similarity to an argument that might be offered at trial. It points out evidence that is in his favor, that is contradictory or countervailing to the evidence offered by the state. And this court asked the question, how can we consider it at this stage? And the answer is simple. It cannot be considered. At this stage, we are here on sufficiency review. Countervailing evidence is to be disregarded. Defendant was certainly entitled to make these arguments to the jury, just as the jury was entitled, as it did, to reject them. And when the jury rejected these arguments, and this case went up on a motion for judgment of acquittal, these arguments no longer had any part to play. They should not have been considered by the trial court. They should not have been considered by the Court of Criminal Appeals. The consideration of this countervailing evidence is the key problem in this case, is what I would point to claim that the Court of Criminal Appeals and the trial court simply failed to follow applicable Tennessee law with regard to motions for judgment of acquittal. And lastly, Your Honors, in talking about the medical evidence, defendant all but concedes that the medical evidence is circumstantial evidence of his client's knowing mens rea. The medical evidence was that the child's empty gastrointestinal tract, that the fat buildup around her internal organs, that her shrunken thymus, these were not conditions that would arise from a few days long stomach bug. That even in the case of severe gastrointestinal distress, that the child would have had something in her stomach. that the fat buildup and the shrinkage in her thymus are not something that arise acutely, that these are indicators of chronic and prolonged malnutrition. This case certainly bears some similarity, Justice Kirby, to many child abuse cases where a child suffers an injury. When they're under the care of a parent, the parent offers an alternative explanation for how the injury occurred. The child fell down the stairs. I certainly didn't abuse the child. And routinely, Tennessee courts allow juries to weigh these arguments, decide which one they believe, and render a verdict based upon that. That's in essence what happened here. The state offered up a victim and an explanation for her injury, failure to feed. The defendant offered an alternative explanation. The defendant was the caretaker for this child, and the jury accredited the state's explanation for how this child's injury occurred. In terms of sufficiency review, that was the end of the arguments. I would urge this court to reverse the judgment of the Court of Criminal Appeals that failed to follow the applicable standard of law under this court's precedent. Thank you.
Thank you, counsel. We appreciate both of you participating in this format so that we can continue to move our dockets along. We will now stand in recess until our fourth case, which will begin at 2:30 Central Time. So we stand in recess.
This honorable court is now in recess until 2:30 p.m.